You look all right. Welcome everybody to this week's edition of Expert Witness with Doug Miner and Stephen Palmieri. We come to you the first and third Thursdays of every month with some amazing content. Those of you guys who do not know Doug Miner started as a CRO. One day an attorney hired him and was like, hey, can you give me, a little advice, opinion on this thing? And then he gave his opinion. And then the next thing you know, Doug got a check from this attorney and was like, what just happened? And he realized he was an expert witness. And now he is a professional full-time expert witness for credit damages. And again, we are coming to you guys here live. Feel free to comment below, ask questions. We are here for the next hour for you guys. CROs, attorneys, anybody in here that is related to the credit industry. And so, Doug Miner, you are in beautiful, sunny California. I'm actually going to be in your state next week. We were just talking about that. Maybe we can even meet up and grab some dinner. But until then, we've got a show to do, man. And you were just telling me before the show that there's actually some pretty interesting Metro 2 stuff that's been kind of making its way into the court cases. And some courts are ruling one way and some courts are ruling another way. And you've been involved in some mortgage type cases, and they kind of tie together with Metro 2. So, man, what's been going on? Open this thing up for our audience here, man. What's been happening in the expert witness world these days, brother?
Yeah, Stephen. So as far as like what we were talking about, I think let's first get into, what I'm seeing just firsthand. Obviously, I have a lot of mortgage contacts being in the mortgage industry forever, and the credit contacts. And literally this morning, I just got a call from a mortgage professional asking me about if I'd been involved in any cases where hard money or lenders had been foreclosing on properties that had lots of equity in them. And just what happened last week, I testified on a case where that particular situation had essentially kind of happened. Meaning there was these forbearance agreements, and I'm not going to name out the servicers, let's say on different particular stuff right now, but keep in mind, I think for the credit repair organizations, that whether it's a mortgage servicer or it's a hard money lender and there's been some forbearance issues or they've been in forbearance, I'm seeing situations where sometimes they're not accepting the checks at some point. I'm seeing a situation where a property was foreclosed upon during that period of time and ended up in litigation. So from a credit repair organization standpoint, I see a lot of these cases. I mean, look ahead. I think we're going to see more and more of this type of issues come up for consumers and lenders in the way that they're furnishing information about forbearances with mortgages and if they're going to foreclose or not. So definitely, I don't know how your credit repair organization guys go about marketing their businesses, but definitely in my world, it's coming up, and so it definitely should be coming up in their world and be on the
Well,
front.
I mean, the most reputable way is to just get those little bandit signs and put them on the street corner, instant deletion guaranteed, and we'll take upfront fees, right? I mean, that's how I think the most reputable ones. But let's back up for a second here, because you had said that they're foreclosing on houses with a lot of equity. I mean, come on, Doug. It's not fun to just always foreclose on underwater houses when you're the lender. Certainly you want to take back some of the houses when you've got some equity there, right? I mean, what's the problem with all of that, man?
Well, obviously, I feel that there could be a bit of a conflict of interest, right? I'm going to not say specifically, but let's just say in the most recent case that I've been involved with, I believe the equity in the property was somewhere in the 7-figure range.
So, Mr. Miner, it's your expert opinion that if they were to take back underwater houses, that would be doing the consumer a favor, but if they take back houses with equity, that somehow is unjust and unfair. Is that what your expert opinion is at this point in time, sir?
No.
Okay. All right. So let's get into the nitty gritty here, man. I like to kind of sort of pin you down, but because you really are an expert, I can't really pin you down because I don't want to damage your reputation. But for those folks who are going to watch this recording and admit this into evidence and try to impeach Doug's credibility, screw y'all, okay? This is just a fun show that we're having here. You should never admit this at the court for anything other than just pure humor, because Doug is a humorous kind of a guy. All right, so let's get back to it, man. What is going on here? So how are these cases starting to look, and how are they coming to you, and what are we doing here, and how's it tying to credit reporting?
Yeah, well, I think it's this thing where I feel like this show sort of straddles this situation between you're a credit repair organization, but if you want to look into doing expert witness work. And so this is a situation where I see credit repair organizations are going to be coming across this type of information or these types of reporting issues and problems for their consumers. And then it's a question of, okay, well, what do you do? Right? Are you going to act as the expert witness? Are you going to refer it out to one of your attorneys that you work with? How are you going to go about setting up the disputes and seeing if you can get it corrected? And if none of that is successful, okay, then how is it going to move into the courts? And is it worth the money and the time to do so? Obviously, look, hey, you have a 7-figure equity or a large amount of equity in the property that you potentially could lose. Then you need to think about how you want to help these people to the best of your ability. And I think having an attorney involved to maybe to put a stop to the foreclosure proceedings, or at least let it play out through the courts before it's foreclosed upon. Because, I think the worst thing would be for someone like to be in that situation and then they'd actually lose the house.
Yeah, let's back up for a second and reframe this. I mean, because you're in LA-ish, Malibu-ish, California. House prices are, I mean, because you're talking about people sometimes with 7 figures of equity. I mean, so, it's not like, you're here where I'm at in Dallas, where an average house is like $250,000 or $300,000. I mean, average houses, I guess, are, I mean, you got, we're in a market where there's certain markets where the houses are 7-figure homes and stuff like that. And so, okay, so are you seeing a lot more foreclosures and stuff like coming now? Is it more than it was previously?
Yeah, it's a good question. I don't have any specific data today for anybody, right?
Yeah.
It's been coming up, and like I said, it came up in a call this morning from a mortgage professional. But yeah, I do understand being in Southern California, the property values are skewed tremendously in the sense, I think where, the median price near where I live is somewhere in the $800,000 range, but that doesn't mean that there's not 20, 30, $40 million houses nearby.
Sure. So let's talk about what the real issue is. Okay. I mean, so from the credit repair perspective, what exactly can they do versus where you come in? So what we're talking about, right, are houses that are in foreclosure, that were in forbearance. I mean, because there's really not a whole lot. I mean, like credit repair is not going to stop you from getting your house foreclosed, right? So let's kind of talk about the scenarios. I mean, are most of these like wrongful foreclosures? And then why is it wrongful? That's where you come in. I mean, what exactly is really the scenarios that we're talking about here?
Yeah, I think I see just in the way you're phrasing it, I see sort of two trains of thought. One being there's a foreclosure proceeding that started, and maybe it started with due to the fact that they're not accepting payments, or there was a misappropriation of funds, or the servicer may not have handled the forbearance correctly, right? Or there's a difference between the forbearance agreement and then what's actually happening, right? So
Gotcha.
I think the whole scenario is open to a lot of problems. That's what I'm saying. And the problem being, if there's a furnisher that's not reporting the forbearance correctly, or then they're not showing the payments that are being made correctly, or not accepting payments that they should be accepting under the agreement, and then you have a reporting issue problem. And if that reporting issue then ends up in a foreclosure proceeding started, it's great.
So we've got Matt Listro. In fact, I'm sending Matt Listro. You got a question here. In fact, I just sent you the StreamYard link, Matt. If you want to come and join in here, we could have a party of 3. Like literally, I just messaged it to you, buddy. But so we can start. If you don't want to jump in, that's cool. If you do want to jump in, come on in, Matt Listro. We would love to have you pop your head in here for our expert witness show. Check your messenger for the link. But so Matt Listro, the one and only Mr. Credit Con, he says, so Doug, can you comment on the practice of stalling the foreclosure using the RFI letter? So, I mean, I think I think what Matt is alluding to is under RESPA, the Real Estate Settlement Procedures Act. There's a provision where you can do a qualified written request, a QWR. You can ask for documents from your loans, and then those QWRs are kind of further defined by the regulations as requests for information and stuff. So I think that's kind of what Matt's alluding to is, hey, can you send a qualified written request under RESPA? They're supposed to respond, I think, within 60 days. They're supposed to actually stop damaging your credit, specifically there in RESPA when that request is being processed. So let's I guess talk about, to the extent that you can. I mean, what are the things that our CROs can do? And I mean, if these people are coming to them in foreclosure, I mean, I would kind of say there's probably not a whole lot that we could do. Honestly, we probably need to find an attorney. So let's talk about what can the CROs do, how can RESPA play in, and where do we go from there?
Well, yeah, I think it kind of goes to the point of, if they're coming to the CRO for help and the CRO wants to send in the request for information letter or dispute the way that the information is being reported, I think all of that's going to help an attorney with filing a case and filing some order to stall the foreclosure process so that they don't lose the house, right? So is the CRO beneficial? Sure. And could the responses to the request for information or a disputing of the way that they're reporting in the information based upon the agreement that they have? Yeah, I think all of that play into these types of cases. The case, this most recent case that I was testifying on, there was a involuntary bankruptcy that was filed against the plaintiff in the case. I was asked specifically to evaluate the impact of the involuntary bankruptcy being filed, not if it was valid or not, but just the impact of it coming into play. And it just so happened that during this period of time, there was a foreclosure proceeding going on with a hard money loan. So my situation is a little more complicated, but I think the main thing is, the point being is that this is something that CROs should be aware of, and definitely have an attorney that could be a referral source for people in that situation and help them out.
The really nice thing for our listeners here is this
takeoff. I like it.
Yeah, this is totally unscripted, and of course, those of you guys who are listeners, every now and then you'll hear me drop an F-bomb when I think my screen literally disappears on me, and I'm like, oh my gosh, it didn't disappear, I'm live. And sometimes we get Mr. Credit Con himself. He just basically gets invited here into expert witness. So man, Matt, you're a little out of focus there, but that's okay. You keep on squirming around, man. Did you take your Ritalin today? My goodness gracious.
Yeah, I'm always squirming around a little bit.
How are you doing, sir? What's going on, brother?
Can you hear me okay?
Yes. Welcome to Expert Witness, sir. Welcome.
Yeah. So we saw everything goes round robin. I've been doing this for 25 years, and we saw this back in 2008, 2009, 2010 after the meltdown. There was a lot of foreclosures. And so we're going to come into that same environment. And so it reminds me of, I like to tell stories, and consumers are looking for help, right? And so sometimes they find themselves in an unfortunate situation of foreclosure. And that's just what it is. For whatever reason, you're there. Got behind, never going to catch up. There's some issues there. And so for the consumers that are underwater, sometimes I tell them a story. And I like to give examples a lot of times with stories, and I'll tell them a story of somebody that I personally knew who stalled that foreclosure for over 2 years. And what they did was they simply it was a husband and wife, and
just two. Oh man, you're a lightweight, man. I know people who have literally been.
It was a little longer than two, dude. But yeah, And so what they did was the wife would file the Chapter 13. And then that stalls the foreclosure for 4 months. And then after that is done, actually, I'll take that back a step. Before they do that at all, you have to make some requests for modification.
Hold on. I'm sorry to keep on this, but for those of you guys who are listening, you may want to, what he's doing, he's giving you the roadmap to to stalling your foreclosure. So if you're needing to do that, go ahead and take some notes, because Matt Listro is going to tell you how to not pay your mortgage for 5 years. So go ahead.
I'm going to do it because, I really don't want to advise the client that they should do that. That's not really my position. So a lot of times what I'll do is I'll tell a story and tell them of what somebody else who did, and then let them make their own decision of what they'd like to do. But it's my job to give them information.
I keep on interrupting you. I'm so sorry, but not really. We need to put the disclaimer in again for Doug Miner's purposes, because I'm sure somebody somewhere is going to find this tape and want to play it to impeach him. This show is brought to you for educational purposes only. Okay, so there we go. All right, so Matt, now tell people how to not pay their mortgage for 5 years.
So I had a client, and what they did is the first thing is they requested mediation, right? And so that takes a little bit of time. And in the mediation, after the mediation, they said they wanted to apply for a loan modification. And there's no way that these people would have qualified for a loan modification. They didn't have a job. There's no income. But they have to give you the opportunity to apply. And so they gave them the opportunity to apply for the loan modification. When that didn't work, because of course we all knew it wasn't going to, but they had to give them some 60, 90 days to apply for the product. And then after that didn't work, they requested through mediation for the ability to apply for another modification program, this one that was issued not through the lender, but through the state. And so they got some additional time to apply for that program, which we all know without a job, they're not going to qualify for that one either, but it takes time. After that,
doesn't make any sense. I mean, I can get me $100,000 in student loans without a job, but why can't I get me $100,000 mortgage loan without a job? I don't understand, Matt. What is?
Yeah, it's not really a fair system that way, is it? And so then the next thing they did, the wife applied for a file for Chapter 13 bankruptcy, just the wife. And that stalls the foreclosure for 120 days. At the end of that period, her bankruptcy, Chapter 13 bankruptcy was withdrawn. And this time the husband filed for Chapter 13 bankruptcy. And so that stalls the foreclosure for another 120 days. At the end of that 120 days, that bankruptcy filing was withdrawn because it didn't make sense. And then the wife goes forward to file for a Chapter 7 bankruptcy. That stalls the foreclosure for another 120 days.
Hold on. I need to, excuse me, Doug, I need to go get some holy water real quick and sprinkle this thing over here, because I feel like something's lightning bolt's about to come and strike down here. So, okay, it can continue on, Matt. So we've got individual.
Obviously. Yeah, and then it continues on. So after the wife filed for a Chapter 7, that stalls at 120 days. At the end of that, then the husband files for a Chapter 7 bankruptcy. That stalls at another 120 days. The moral to the story was this was a couple who was never going to be able to come out of water on this mortgage. It was the meltdown. They were way underwater. It's never going to right itself. What do you do? And so what they did in this opportunity is they used the time that they could buy through this method of trying their different modification applications, bankruptcy, trying different bankruptcy vehicles. But all that time, they were living in the property rent-free because there's no mortgage payment. So they were able to save enough money during those 2 years that they had a nice little nest egg when they moved out. And I think the lender at the end actually paid them $3,000 to move out, gave them moving expense money to move out. I'm not positive of that, but I could be getting them confused with another couple. But oftentimes the lender will also give a homeowner some money to move out of the process, to help the process move more smoothly at the end and get them out of the property. Anyway, but the moral to the story was this was somebody who found themselves in an unfortunate situation. The market turned around, they were underwater, and I'm just trying to show how they used the situation to their advantage to try and put some money aside so that when they did leave that property, they did have their first month, their last month, their security deposit, and in fact, they had a little bit of money saved up to when they were going to be able to buy their next house and re-enter the mortgage market again. And so that's just a piece of advice.
It's actually a really good story there. I mean, so it's unusual that most folks who are not paying their mortgage are actually saving money. I mean, let's just be honest with each other. It ends up going somewhere. Like, it's kind of like as if you were paying your mortgage. And so if these folks were able to save money.
That's the tricky part. But yeah, they were no longer paying their mortgage. I mean, they had gotten this mortgage. And yes, they lost a job, and so they had some financial issues there as well, but there was still some income coming in there. They still had some money coming in, but they weren't paying any rent. And so at least that way they were able to save that. They weren't paying any mortgage payments. So they were able to save what money they had and put it aside so that when they did have to leave, at least they had a little something to fall back on.
And
so I know when they purchased the house, they never intended it to be a bad investment. Nobody ever buys a house and says, hey, I hope 2 years later this property is worth $100,000 less than it is today. But the fact of the matter that sometimes that happens. Sometimes it's a poor financial decision. And then you have to say, what am I going to do from here? And some consumers don't know what options they have. And some consumers will never want to take advantage of that option. They don't want to be in the property and sitting there occupying the property without paying anything. But other consumers will say, you know what, I need to do that. That's my situation. And I have a family and I have to take care of them. And this is what we're going to do. So sometimes just letting them know the options and they can make their own decision.
It sounds like, based on what you said, they never even litigated against the mortgage company. I mean, they just did the bankruptcies and the other stuff, but they never actually sued the mortgage company, from what I'm hearing, right?
Correct.
Yeah, I mean, because that would have bought them a whole bunch more time.
Yeah. That's what I was talking about in the question to Doug. The request for information will stall unless the foreclosure is in the very final stages. The request for information can forestall that foreclosure as well. And the idea behind the request for information is you're looking for anything that the bank may have done wrong. And I haven't done a ton of them. I remember, Doug, if you remember, I think you were at the convention where we had the former Attorney General in Ohio, Mark Dan, was there. We were at the convention. He was there. He talked about the RFI and the NOE letters, and they do a lot of them. And he said, these are his words, not mine, that they were finding 75% error rates when they examined the pay history and documentation of the mortgage. And the idea there is then you can take that error, whether it's a pay history error or a documentation error, and try and leverage it to the borrower's benefit to either get them new terms, stall the foreclosure, to do something for their benefit if you can find something that's wrong. Twice in my career, I think they were both with Chase, we were auditing a mortgage, and we found that the documents were executed on the wrong day, that someone signed the mortgage documents, and it wasn't an attorney closing state, it was a notary state, and then the documents were notarized the next day. And unless the consumer was signing at 11:59 p.m. and then the notary was signing after them, I don't really understand how the consumer signed it one day and it wasn't notarized until the following day. That doesn't seem to make any sense. And so then we found some deficiencies in the document and then had something to argue back with Chase Manhattan Bank. So sometimes the idea here is just looking for something. What do you have to argue about?
I'm with you, Matt. I think it sounds like you're referring back, with the meltdown, 2008, 2010 range in there. Absolutely. 25 years of my career in mortgage lending and being around all of that my whole life. I don't think any of the mortgage servicers or the banks or any of them were really prepared for what came, right? And so hence your 75 or 80% error rate. That doesn't surprise me at all. What would surprise me is if it was 70 to 85% today, as we move into this forbearance problem coming back into the market and some of the reporting errors that look to seem are going to start happening more and more as we move forward, right? Hopefully it's not the 70, 85% or whatever it is, but I think the point being is for this call in the credit repair organizations that, this stuff going to be coming up. There's going to be inaccuracies, and they need to have a good, solid approach and a way to go after it and help these people. And that story, Matt's awesome. I mean, I get it too. I've had those same stories where people have been in their house 2-3 years, and then eventually they moved on. And just like you said, I agree with you. Here in California, I have a couple stories where people were given, whether it was $4,000, even $8,000 or $9,000 in some cases, to move out. So, hey, unfortunately, if that's the route you choose or that you find yourself in, I mean, I agree with you, Matt. You're making the best of a difficult situation, and they have to themselves.
They got to make that choice, and I think Mark, Attorney Mark Dan, the former Attorney General of Ohio, when he spoke at CreditCon, I think it was 2018 or 19. And so it was significantly after the meltdown, and they were still finding errors. And there's a lot of, I remember one in particular. Now, I haven't done a lot of this myself, but I remember one that I did, and we found that the consumer, prior to the foreclosure, the lender was doing some kind of inspections. And then they rectified their loan. They got a modification. They came out, and everything was fine. However, they were charging a $15, it was some small $15 a month fee to check on the house to make sure everything was okay every month while they were in that foreclosure process. But that charge continued. A month passed when the loan was reinstated and everything was fine again. So that was a $15 charge that never should have been charged. It's an erroneous charge. Now, you can argue how material did that borrower being overcharged $15, how material was that to the borrower's ability to make a payment? Well, that's, I found something that's wrong, and now we have something to argue about. And that's up to a court to decide how material that $15 overcharge was, but it's still something that was wrong. And a lot of times they're going to try and compound that violation by, in the request for information, the lender has 30 business days, which is essentially 45 days, to respond to that letter. But they also need to let you know within 5 days of receiving it that they received your letter. And so oftentimes they don't hit that 5-day mark, and they don't send you a letter back saying they received it in a timely basis. And that's another violation. And so what we're looking to do here is we're looking to stack different things, right? How many things can we find? And can we stack this small thing on top of this small thing on top of this small thing? And then we just become a little bit irksome in the lender's side, and they want to try and do something and get you out of the way. So that's what we're trying to do. Even if it's a small thing, we're looking to what can we uncover? How can we help this consumer?
Yeah, so I think for those, for our audience here, though, I mean, I guess it's kind of important to consider what condition your client is in. I mean, if they're like currently like in foreclosure-ish kind of a status, I mean, most probably you can't do anything for them, and we need to probably find an attorney or somebody, So, I mean, the real life application of this is, okay, if we have somebody that already maybe has a foreclosure, or maybe they're just 1 or 2 months delinquent, maybe we can be a thorn in their side. But if you got somebody like really is kind of in that foreclosure condition, that's like a whole other animal there. And so now, go ahead, Doug.
About this, so just listening to all this, what strikes me is, as CROs, so you have individuals or couples that come with these types of problems, right? I think the questions that come up is, how bad is this going to affect my credit? What's it going to look like? Am I ever going to be able to get credit again? You have to be, I think it's more about letting them understand what's going to happen, but then also giving them a path to recovery, right? Because you file the BKs, like you're saying, Matt, whether it's 13s or 7, you got these BKs on there. How are these people going to recover from that? You got to give them well, at least in my opinion, I think it would be a good idea to have a pathway to say, hey, this is an option that you have, and I understand it could possibly be scary, but here's a pathway to recover from it if you choose to go that way.
So Doug, so for some of these cases, I mean, like Matt was kind of talking all these theoreticals and hypotheticals, which are great for credit repair because we're a game of leverage and, just putting the thorn in their side, right? But I mean, like at the end of the day, there may be some limitations to how you can answer this because as an expert, all really usually is what like your attorney gives you and is like, hey, give me an expert opinion on this. But like, I mean, when you go to the judge, some of these judges could just be like, yeah, I mean, there's some technical errors and this and that, but did you not pay your mortgage for 2 years? Your time is up, right? I mean, so, what the extent in your experience to where the judges, I mean, they're just like, dude, they didn't pay their bill. I mean, bank needs to take their house back. How does that play into, the cases that you're in?
It's a good question in the sense that I wish I could answer it better than I think I'm going to. Because keep in mind, a lot of the times in my capacity, I'm not around for what the judge is going to rule on. I'm not there to hear it, or like you just said, I'm given a limited scope of information and a limited scope as to what they want me to look into and opine about. So that's a tough one. I feel like I'm doing a disservice to you and everybody watching, but
Well, no, I mean that's true. I mean, and that's why I kind of questioned it that way, because that's what your job is. Your job is to take what your lawyer gives you and then write an expert opinion on that. Your job is not to go out there and be a fly on the wall for the whole case. But so why they hire you, right, is to be able to assess damages to these consumers, right? Like that's why you get hired, is for most probably a damage expert report, right?
I would say that's probably one of the particular things I feel like I'm best equipped to do, is to assess the socioeconomics and the financial impact. And Matt brings up a really good point. Is it material or is it not material? Or if it's material, to how much, right? So yeah, and I enjoy that part of it. It's always been a part of who I am, doing the financial side of things. But it's marrying that real life and then actual out-of-pocket costs, future lost opportunities. All these types of things come into play, but you have to take it in the context of the individual. So you bring up a good point, right? The person living in Malibu in Southern California that has a large, I don't know whether it's a 6 or a 7-figure income, the financial impact of that person in comparison to someone with a 5-figure income and the property value is 150,000. There's the numbers are drastically different, but
So
like it's still material to that individual. It doesn't. Sometimes it's not necessarily the money amount. It's like, look, the impact on the person with the $150,000 house may affect their life more. $10,000 might affect their life more than $100,000 to the other person.
So let's talk a little bit about how you do what you do. So, you get a couple cases. Maybe one's got 150,000 in equity. Maybe one has $1 million in equity. And so your attorney hires you to give some sort of an expert report on damages. But is it relevant to what your job is, like whether the bank screwed up or not? I mean, like if these people didn't pay their mortgage for 2 years, I mean, like let's say it really is kind of a legitimate, like there wasn't really a whole lot of screw ups, but certainly the consumer is going to be damaged. Well, I guess you can say they're going to be, because they're going to lose their equity. Like, is the fact pattern of what the mortgage company did, relevant as to how you assess damages?
I think so. It's going to go back to, it depends on what I'm asked to do in that particular situation. The easy answer, I think, is most likely if all of those things tend to come into play. Or let me rephrase it this way, in saying that even if it's not what's being asked of me, it doesn't mean that I don't understand those things, and my experience tells me these are the types of things to be looking for. So I may communicate to the attorney who's hired me and say, hey, look, what about this or what about that? And question some of the things that you're bringing up. And there may be an issue of, well, Doug, no, we don't want to get into that issue because of X or Y. Or, oh, Doug, that's interesting. Can you go further with that? We'd like to incorporate that into what we're doing, or into the complaint, or as part of your testimony or your declaration, whatever it may be. So again, it's a case-by-case situation, and I think it's an attorney to attorney situation, depending upon how they want to approach the case.
So what about securitization audits and all of the hairy, nasty, non-compliant, illegal things that these mortgage companies allegedly, and in fact actually do, with securitizing these things, violating the tax code and everything else, packaging these things up, selling securities that are not worth what they're selling them, swapping out securities and trusts that they're not supposed to do under the tax code, these REMIC trusts. There was a guy named Andrew Lehman. He had a company called Certified Forensic Loan Auditors, and unfortunately the CFPB went and squeezed his ass out of business. And he's in our group here, but he had this whole thing with Bloomberg. Bloomberg could show you the securitizations, the trusts, all the assets that went in there. And he would literally, you could buy a securitization report. I've gotten a couple of these for clients. One of them actually did a suit against the mortgage company, and the judge here in Texas said, yeah, although there's things wrong with the securitization and everything like that, and they broke a lot of laws, unfortunately, it would have to be somebody involved with the trust, like a bondholder or somebody who got defrauded that would have to have standing. The consumer has no standing for what the mortgage company did as far as violating the REMIC trust laws and stuff. So that didn't really go very far, which is kind of unfortunate, but that's the way things go. But I mean, and then there's a guy, James Kelly, in here as well. He knows how to look at those Bloomberg reports and look at the chain of title and figure things out. We actually did a show with him a few months back. But do securitization audits, and there's almost assuredly all sorts of errors in there. Whether the consumer has standing to argue those is a whole other issue. But does that ever come into play for the cases that you're in, or do you think maybe that's something that should come into play moving forward?
So from on the cases I worked on, it has come into play. Not necessarily within the scope of what I'm asked to do, though. But I'm aware of it going on, and occasionally, because of my mortgage background, I can opine to a certain extent with regards to mortgage servicing and the handling of things like that. But a lot of times they may have somebody else to go into it a little bit further than what they're asking me to do.
Yeah, I mean, because you're not really a securitization expert, but you'll say that. So I mean, some of the cases that you're on, though, you'll say that those attorneys are bringing securitization audits into the lawsuits. You are seeing that.
I would I guess it's come up in discussions on cases.
Yeah.
But it's sort of outside of the scope of what they would ask me to do.
Because I mean, I would just imagine. I mean, if an attorney is really trying to, I mean, if you've got like $1 million in equity or even $500,000, I mean, and you're going to have enough balls to sue a big mortgage company, you're probably going to want to pull as many tools out of the toolbox as you can, to give you as many causes of action against this mortgage company, So I was just kind of curious if that's something that you're seeing there. So
I see it in the Matt brought it up perfectly. Actually, his description of it was you're sort of adding on all of these different violations and just adding to the case, right? So yeah, I do see those types sort of I guess it's approaches.
And so this is kind of on topic. Matt has a really good story when he put the squeeze on this one mortgage company once. He had a bunch of recorded phone calls with them, and and we're talking to CROs. I mean, sometimes we have clients that are beyond the foreclosure status, and this thing is nasty and still reporting, right? I mean, I think, Doug, that's a big part of where our audience can also get some value here, is like maybe they've already been foreclosed or whatever, and this nasty ass thing is still reporting. But Matt, I think you know what I'm alluding to. You've got this story that you tell all the time where you had to kind of call the mortgage company and they kept on reporting this thing late for like 10 years or something wild and crazy. Why don't you kind of tell us that story? Because I love it, how you, and then the guy was all ballsy and stuff until he found out that he was being recorded. Next thing you know, he's like, oh, we're going to go ahead.
Yeah, it was all fun and games until he thought all of a sudden he might have a repercussion. So that was a little tiny lender in I think they were in Connecticut. It was a second mortgage lender, so it was a mortgage bank, and they had made a second mortgage to an individual. And in my research, what I found out is although they made the mortgage loan back in the early 2000s, they didn't apparently, for whatever reason, start credit bureau reporting until 2017. So when they started, because I know this because I did his credit repair in 2015 and there was nothing on his credit report, it was fine. And then all of a sudden he comes back to us again in 2020 and lo and behold, there's this account on his credit report that says he hasn't paid his mortgage and didn't exactly make sense. So anyway, we sent a bunch of letters. The lender didn't understand or acknowledge. So the first time I called, a representative at the lender said that the account was continually 120 days past due, and that they were going to continue to report this 120-day past due account literally for the 30 years of the mortgage. She said, no, we can report it as long as we want. And so I confirmed with her that the last time the borrower made a payment was in 2009. I might have that date slightly, where it was either 2009, 2010. And they were due for the January 1st payment 2010 or 2009, whatever it was, literally a decade ago. And I'm like, it doesn't work that way. You can't just continue to report somebody late every month. How come you don't put them into foreclosure? Well, we can't. we're a second lien holder. And that's completely false. A second lien holder can indeed foreclose, but this is what they're going to represent to me on the phone. Well, we can't foreclose. Well,
or
you can still
to you. They
misrepresent is, I like your word better, misrepresent, because, you know, I'll say this, the person on the phone probably was uneducated and didn't know, but that's okay. So I have a phone call with them saying,
you know, we
120.
Like
yeah, we like that stuff, you know. And so I make another attempt to call back, and this time I get what I believe is her supervisor. And the funny thing is he contradicts her in the phone call, saying that, no, we're reporting 150 days past due every month. Really? Your last representative said 120. And I asked him if he was willing to go and pull a bullseye, and he said, no, there's no reason for us. I know what we're reporting. It's what we report. There's no reason for, I'm sorry, a bullseye, for those listening, is when a furnisher of data requests a bullseye. A bullseye is a term in the eOscar system that says, show me how the account looks on the credit report. So it's kind of like an audit. You want to see what, not just what you've been reporting, but show me what it looks like in your system. It's called a bullseye. And so he's not willing to check it. I asked him, well, you know, we sent a letter to you. It went in certified mail. It took you 40 days before you even responded to us. And his issue was, well, we've been busy. You know, we have to put priority on customers, other customers here. We can't prioritize this because we already dealt with you on this, and we already dealt with you, so we don't have to deal with it again. And it was just crazy that, you know, he's saying this. And at one point I said, well, you know, I'm recording these calls so I can go back. You're saying it's 150 days late. Your last representative told me it was 120. He said, well, you misheard her. I said, well, we can go back and listen to the recording. I'm recording these calls. He said, what do you mean you're recording these calls? I said, well, I'm recording the call. He said, well, I didn't give you permission to record the call. I said, well, you don't need to give me permission to record the call. Connecticut is a two-party state. They were in Connecticut, but at the time I was calling, located in a state that was only a one-party call. For those listening, you do want to be careful of those laws. I said, I have every right to record the call. And then he said, well, I'm going to terminate this conversation. And then the next day, I got a nice letter from him in the mail. I forget what he said he was going to do or something, but they all of a sudden were taking a little bit different position the next day once they knew we recorded it. And, you know, I really should follow up with that. That case, we did get to an attorney. It was either John Watts or Mike Cardoza. One of those two has that case. I don't know what's finally happened with it, but you will be amazed at the crazy stuff that these lenders will tell you on the phone. They'll just tell you what they think is accurate, even though it's not accurate for the law. The law doesn't say you're a second lien holder and you can't foreclose. Of course you can. So just have these conversations, do your documentation, and you will find that lenders will trap themselves. Like I mentioned before, Chase Manhattan Bank twice sent me mortgage documents that were executed wrong. All they had to do was look at it before they mailed it to me to see what they were sending, but they don't do it. They just print it off, put it in an envelope, and send it out to you.
Well, Matt, as the old saying goes, it's all fun and games until they report you a decade later. So that is something else, man, which goes to show you the power of making phone calls, though, which is where that third party POA disputing.
Absolutely.
You know, both you and I, we've been doing for 10 plus years, you know, that if you're just firing off stuff in the consumer's name and jick-jacking, you know, you could not have even done what you did, right? I mean, you know, because the guy knew you weren't the consumer, because he knew he was talking to Matt Listro. And so that goes to just kind of a little sidebar segue, the power of using POAs. You know, it allows you to do more than just fire off letters. You can actually, if you need to, make phone calls, and you can record those. And those are especially beneficial when you're dealing with debt collectors as well. And so,
yeah.
All right,
let's be clear, as a general rule, it's not a good business practice to get on that phone. You know, our business is time and money. And it takes a lot of time and money to get on that phone. I mean, you'll spend 20 minutes on hold sometimes before you get somebody. You can't make a business on calling on every account for every consumer. It's not possible. But it's very nice to have the option to do it with the power of attorney, so that when you want to, when you need to, when you have a client that's getting less significant results and you want to do something more, if you have something that's really important to a client, you have the ability to bring out that big bat and hit that lender over the head with that POA.
Well, and even, I mean, you're exactly right, but even without doing phone calls, you know, to be able to send POA on your letterhead letters to executives over at these companies, I mean, they're going to treat those, if you say something intelligent in there, they're going to treat them differently. If you look like a retard, then they're going to be like, well, this guy's clearly a dumbass, and so is his client. So, I mean, so it is important to know what you're doing, right? But I mean, if you've got things to say that are legitimate, you can send those up the chain of command. That POA really does help. But we digress, Doug. Well, let's go ahead and give it back to you, man. So, all right. So you're seeing quite a few of these cases, different flavors, and how are they going? I mean, are these people being able to stop the foreclosures? Are they able to recoup pain and suffering and equity? I mean, what are we seeing with these types of cases when you get a guy who unfortunately has a crap ton of equity, but unfortunately also has not paid their mortgage in 2 or 3 years?
Yeah, gosh, I mean, I can't speak specifically to like all these different cases. I sort of feel like, Matt, there's a part where some of them get mixed up in my head. I'm talking about one and it makes
just fabricate something that just sounds really good for radio and television here. You know what I mean? People don't watch here to learn; they just watch here to be entertained. So
yeah,
we're just joking, by the way.
Well, I think I've seen different, at different times on different cases, whether it's they were able to hold up the foreclosure for a particular period of time, or it's helping them recover afterwards. Because it's interesting. I do get that sort of question comes up with me fairly often in cases where if I'm on the plaintiff's side and there's all of these things going on, and they're sort of and they want to know, okay, Doug, well, after this case, can you help me with things? And typically I usually can in the sense of explaining to them what they should be doing, how they can go about it, do they need to do credit repair, not credit repair, those types of things. But
if they're kind of like, I mean, if these lawsuits, so would you say that a lot of these lawsuits that you're dealing with, I mean, they're kind of currently in the foreclosure process, they haven't actually been foreclosed? Is that kind of where they are in the stage of the process?
No, I would say it's both. It's in the beginning stages, in the middle of it. It could be after the property's been foreclosed upon. I've had a few after the property's been foreclosed upon. But the one thing that kind of pops in my head listening to your question is, and I sort of feel this way every once in a while, like you say, somebody has all this equity in their property. They're not making their payments. Well, why the heck not sell the property? Right? I don't know. I mean, it sounds overly simplistic, but if you've got $1 million in equity in your property and you're having trouble making your payments, and why are you spending all this money on attorneys and dealing with all this crap when if you sold the house, you could still sue them for whatever happened previously, but at least now you don't have the stress, and at least you can walk away with in the property. And I don't know. There's that very
stop the bleeding. Yeah.
There's that realistic, real life sort of. You gotta. I mean, I look at it that way as well. I think that's part of being an expert witness. You need to have the ability to sort of look at these situations from lots of perspectives. At least that's it's a benefit to me. At least it's part of my personality, and I do like to look at it and in the right forum, in the right situation, voice those sort of concerns or opinions about things.
Well, yeah, I had not even thought of that, actually. That's the most obvious thing in the world, is to put the house up for sale, right? But I mean, once you're kind of in, well, especially if you have equity, because we're talking about houses that have equity, right? I mean, which is kind of unusual, because usually we're talking about houses in foreclosure that are underwater. Then you've got a whole other issue of trying to sell it, but you're underwater, which you may not be able to sell it because the payoff plus all the penalties and everything is way higher than the market value you can get there. But yeah, I mean, if they have all this equity in it and they don't sell it, I mean, I can just see a judge just kind of like, saying, hey man, but sorry, the bank needs to take their house back. That's kind of why I was asking you, because I mean, it's just hard to see judges ruling in the consumer's favor in any of these. I mean, maybe you'll give them a little bit of damages, but I mean, these banks have so much power and control, and all these judges are just going to kind of reduce it down to the simple. Why didn't you sell it and get your equity? Well, you didn't. Well, too bad. So sad. And so that's why I was wondering. I mean, maybe are your attorneys trying to get some sort of like maybe a little extra time before foreclosure, maybe or are they trying to maybe force through the court another underwriting analysis for a modification? I mean, like if it has not been foreclosed, I mean, what kind of remedies are the consumers' attorneys trying to seek here? I mean, are they trying to stop the foreclosure? What if the guy can't pay for it? What are they bringing in these cases? Like, what kind of, other than just monetary relief, what are they actually doing to try to keep these people in the houses? Is that part of kind of the pleadings and stuff? Like, hey, judge, we want you to grant us an extra 6 months to try to sell it, or we want you to force the mortgage company to run us through a modification underwriting thing again, or what? Like, what are these attorneys asking for to try to keep these people in the houses versus just trying to get them some monetary financial damages awards or something?
It's all of the above. You're talking about individual these couples, and everybody deals with stuff like this differently. It's there's so much that goes into answering your question, right? So the answer is, yeah, all of those types of questions come up. But sitting here listening to this, I think that the difference, let's say this time around, with the round of and this type of things that I feel are going to be coming up more and more with the forbearance agreements and the reporting of the information and possibly filing for foreclosures, is this particular issue, is that there's a higher probability that there's going to be equity in these properties than when we went through this stuff in 2009, 2010, when there wasn't any equity. That's the big difference, I think, in these situations. And so, like you said, Stephen, you think a judge is going to bring it down to its most simple, basic, resolution, and selling the house might just be the simplest, easiest way to move on and take the money and at least now you can go rent a place and work on recovering your credit and building it back up and moving on with your life.
It really is it's an interesting topic. I mean, this was interesting in 2008, 9, and 10 when the whole mortgage meltdown happened. But just to hear you talk about this, I mean, I guess maybe we live in a bubble or something, but we have been in this whole COVID environment for a year and a half, economic environment. But like Matt's talked about, he's had people from FICO talk at CreditCon, and they were like, hey, credit's looking better than ever because of all the stimulus money and everything that's being the free money that everybody's receiving. And like, you would never know that all these jobs were lost and people are unemployed by looking at the credit reporting. And then they hear you talking about, well, you're getting all these foreclosures. It's kind of a sobering conversation, because, well, there are still people out there, who are suffering and negatively affected, right? And what do you do when you've got a boatload of equity? Now, let me ask you this. On the flip side, are you being called as an expert for foreclosures that don't really have equity, that are underwater, but they're still just trying to sue to save the house? Do you see much of those, or is it more just, hey, I've got equity and we're trying to get what we can from this thing?
Yeah, I would say, more recently it's people with equity, and it's sort of maneuvering around and is the job coming back? Can we sell the house? The market's good. I don't know if it's an inheritance or the business has picked back up and now we're back to work. Things are going to be okay. And like you point out, hey, now that the job's happening, now the checks are starting to come in, can we do the mod? Right. All of those things combined in different.
One thing a lot of people may not really realize, though, but it actually costs the bank money. When what do they call it, holding costs or carrying costs? There's some term for it. Doug, you may be able to fill me in there, but like every month when they're sitting on a mortgage that you're not paying, the consumer is not paying, it literally is costing them money because they're borrowing the money from elsewhere, and then they've got.
Don't forget your insurance and taxes.
They've got to pay your
got to be insured. Got to pay those taxes.
And those are real expenses. Like they have to fork out real money, for
mortgage
your
insurance.
taxes. I mean, so it's not necessarily like the banks are always the bad guy in the deal. I mean, certainly we don't like to give them too much credit, but there are real hard costs that they've got for these defaulted mortgages. And if they're sitting on them for 2, 3, 4, 5 years, I mean, there's actually kind of a legitimate expense that they do have to deal with. And so, where your value comes in because you're going to have to make your pitch to the judge, and they're going to make their pitch to the judge with what exactly I just said, right? Which is, well, hey, judge, I mean, thank God this one has equity because we got to make up for not only the carrying costs for this one, but all the other ones, right? I mean, they're going to have their pitch to the judge as well. I mean, judge, if we only foreclose on underwater houses, what the hell is the point of having risk-based pricing? I mean, so there's two sides to all of it. So anyway, I can see Matt's got his finger up there. I don't know what.
You know how I like to do that. Hey, hang on.
Were you picking a booger, or what are you doing there?
Yeah,
man?
you triggered something. And listen, you guys were very nice enough to let me join in, and I really appreciate that. So I'm going to ask for indulgence for just another minute, because you triggered on something that I thought might be very helpful for some of the listeners. In the foreclosure process, things don't always make sense. But ultimately, there's usually logic behind it. And so I wanted to share yet another story that may help you in dealing with consumers and giving them the proper education. So one of the issues that we've faced in the mortgage meltdown years ago was that lenders seemed to be illogical in what they would accept from an offer for a consumer who was being foreclosed upon. So let me give you a for instance. I'm just going to put this in real world numbers because it's often easier to understand. So a consumer buys a home, they go into foreclosure, the mortgage, obviously the market crashed and the home is no longer worth $200,000. They got a $200,000 home, they got a mortgage for $200,000, but now all of a sudden the house is only worth $140,000, right? The market's gone down. And so the borrower goes out and they put the house on the market, they work with the lender and they find a buyer. And the buyer is willing to buy that house for $150,000, $10,000 over the market price, right? And so they're thinking there's no way the bank isn't going to take this offer. We're going to sell the house. Everything's going to be great. And then the bank comes back and says, no, we refuse the offer. And you and I in the public, we look at that and we go, oh my gosh, they're nuts. They got $10,000 more than the house is worth. Why are they not accepting this offer? But sometimes the mortgage servicer, the bank who has the property, isn't the owner. They're a servicer. They're not the owner of the mortgage. The mortgage has been secured by a REIT, a real estate investment trust, and they are the actual owner. So the servicer, the bank you're paying those payments to, the bank you're dealing with in the foreclosure process, isn't the owner. And so they're going to the owner, the REIT, in order to get approval to sell the house. And what happened a lot of times back then was the REIT had specific contractual terms on Wall Street that they must deliver a certain percentage of return. And so they could not legally accept that offer to buy the house, even though it was a great offer, it was above market value, because it violated the terms to their shareholders of what they were supposed to return for an investment return. And so they did turn it down. And then what would happen in our world, what would happen is the bank would then go foreclose on that property. They take it back. And when they finally sold it, they sold that house for $125,000. People said, look, how dumb is that bank? They had $150,000, they wouldn't take it. And now all they got is $125,000. But the problem was their hands were tied when the borrower was in there, because on that mortgage note, they couldn't take that reduced amount because the REIT stopped them from taking that significant loss on the property. So sometimes if you understand that there's some things going on behind the scenes when you're trying to get that foreclosure and short sale done, that may seem illogical, but usually there's a reason behind it. Hopefully that's of some help.
The mortgage company was not the dumb one. You know who the dumb one was? Those poor schmucks that bought all the bonds and everything backed by those shitty trusts that they jammed those worthless mortgages in. All the poor school teachers and the retired people and their retirement funds, which I'm kind of being sarcastic, but it's actually true. Like when you look at what happened, I mean, because they took these 550 credit score consumers and they packaged these up and sold them as AAA rated securities and AAA rated bonds, right, Doug? And it's kind of like, how in the world do you do that? And they sold these things on Wall Street, and who do they get sold to? They get sold to the poor W-2 9-to-5 worker who's just trying to invest in his retirement account. And I mean, at the end of the day, like, that's really the ones who are getting hurt. I mean, the consumer, yeah, I mean, whatever, they're gonna lose their house or whatever, but they didn't pay it, unfortunately. But all these people that bought all these financial instruments securitized by these worthless mortgages, when they were rated AAA rating, right? That's really kind of the moral hazard of this whole thing. So, You know, I mean, hey, that's what makes the world go round. There's nothing, you know, it's always changing and stuff. So, Dougie, as we kind of land this in here, man, what kind of anything you got kind of in closing thoughts here, man? This has been just a freaking action-packed show here today. My goodness gracious, man.
Look, I love. I'm super stoked to be able to talk about it, and having Matt. Super stoked to have you, Matt. And it's what's coming up in my world, right? So, and I'm super grateful, right, that I have this mortgage background and that I can go in. And I think the maybe the sort of byproduct of this is understanding that if you want to do the expert work, there's all different ways you can sort of approach it, right? My background being in mortgages, and how that's why this conversation started, right? It's a mortgage guy calling me, and I'm working on a case where I just testified, and so, I mean, sure, if you were in auto finance, I'm sure there's other areas that I'm missing right now, but I'm just glad we could kind of dig a little deeper on this topic today and get all three of our points of view, and I think when you pull all three of us together like this, it's only beneficial to all the CROs watching. And if they're interested in doing the expert stuff, maybe it spurs them on, or maybe they go out and make a better connection with an attorney that helps a client. I don't know.
You do like talking to people and mentoring people, so they can go to dougminor.com, right? DOUGMINOR.com. Or they could just send you a Facebook message. They could definitely reach out. I mean, any other ways they should reach out to you if somebody is interested in talking to you?
Yeah, I mean, they can just call me directly. I don't, just my office. Give me a call. They put you through to me. I'm not some I'm pretty.
Dude, you're the friendly and approachable expert witness guy. I like that about you, man. So that's right. This guy, he will talk to you. And so, especially if you buy him lunch, then he'll really talk to you. So, yeah, so DougMinor.com, and of course, Matt Listro. You want to plug CreditCon? By the way, did you spend all that CreditCon revenue in Sicily for the last month? You were on vacation on the beach for like almost a month, weren't you?
Yeah, 3 weeks was a fun time in Sicily. Really was a great time.
So we have CreditCon coming up next April. You want to give us a quick plug for
April,
that?
yeah. Thank you for the plug opportunity. It's April 11th, 12th, and 13th. You're going to be in Las Vegas. So right at the center of the Strip, we're going to be at the Paris Hotel and Casino at the center of the Strip in Las Vegas. It should be a good time. Please put it on your calendars and save some time for us.
There's no should be. It will be. Even if you end up like throwing up all over the place because you're drunk, it is still going to be a good time, Matt Listro, right? So, and then of course, if you guys like what you see here, we do have our training course. Go to creditrepairtrainingcourse.com, 30-day free trial, and just $99 a month after that. Would love to talk with you guys as well. Feel free to message me. And that being said, I think we will sign it off, guys. And then for all of you guys, we appreciate you all watching, and we will see you next week on Expert Witness, or excuse me, on Legalese with John Watts and Stephen Palmieri. Talk to you guys later.
All right. Thanks, guys.